Welcome back to Wealth Wednesday. My name is Bryant Stone, Chief Investment Officer of Polimeni Tax and Financial Group. Appreciate you guys coming on again as always. This week's topic, we're going to talk about the differences between a will and a revocable living trust. Okay, so if you were on a couple episodes prior to this one, we were talking about the pillars of our financial planning process. And one of the pillars in our financial planning process is identifying estate planning. Do you have an estate plan set up? I always like to joke with people and say, you do have an estate plan set up. It's either your estate plan or it's the government's estate plan. Which one do you want, right? So we like to identify that with a lot of our clients and making sure that they do understand that. And the most common question that I get as a financial advisor is, what's the difference between a will and a trust? Okay, so we're gonna talk about that today. So let's first start with a will. A will is essentially a document that tells the probate judge what your wishes are. You can list whatever you want into a will. There's tons of different types of wills. We're not going to get into all that today. Wills are state specific, okay? But essentially it tells the probate judge what your wishes are upon your demise, okay? A will does not avoid probate. Probate is a very serious process. It's a very costly process, and will does not, if you have a will set up, that is not going to avoid probate, okay? It does not protect your assets from creditors, okay? So if you have liabilities out there, creditors can have claim to those assets before it goes to your beneficiaries. So that's something very important to be cognizant about, okay? With the will, once again, it tells the probate judge what you want to happen. So what that means is that you're going to incur, well, not you because you'll be gone, but your beneficiaries will incur costs for court and administration fees. So you're going to have to hire an attorney, hire a personal representative. I mean, I can tell you horror stories of people, spouses, children who have had loved ones pass away and they couldn't even access any of their assets because either they didn't have an estate plan set up or they had a will and it was caught in probate and they couldn't touch any of the stuff, okay? By having a will and that going to probate, now it's a public process. There's no privacy. Anybody can look up, your will, and they can see what your liabilities were. They can see what money you left to who. They can see, what your assets were. So it's a very public process, and that leaves your beneficiaries at prey because there are attorneys out there. There are people that are in, real estate, investors, people that prey on beneficiaries who may have inherited some property, some assets. And now that it is a public process, they purchase that information. So do you want, your stuff upon you passing to be a public process, okay? And also with the will, you also run into the problem of having that will contested. Someone can contest the validity of that will and also can contest the validity of if you left a certain asset to someone. So a will is a good starting point. Now, in our practice, being a fiduciary, we typically do not recommend that, but obviously, once again, it's ultimately your choice and whatever you want to do with that, okay? Now, with the revocable living trust, totally different, avoids probate. And that's probably, I can just stop right there. That's solely right there the biggest thing that a revocable living trust does. It's going to avoid probate, so you're not going to have any headaches as far as your beneficiaries being put through a public process, having to pay, attorneys, personal representatives, having, possibly, people in the financial world preying on them because they know they have assets now, things of that nature. So it avoids probate. When you pass, it protects your assets from creditors. It doesn't protect your assets while you're living, but once you pass away, that revocable living trust protects your assets from creditors upon your passing, okay? We touched on this a little bit. It's a private process. It's not public. People can't look up your trust. They can't purchase that information. They can't see what you left to who and how you left it. So it is a private process. The assets will pass directly to beneficiaries. as long as the assets are funded into the trust, which is, that's a very important piece, because a revocable living trust is worthless unless you actually fund the assets into the trust. And what that simply means is that you're retitling the assets in the trust's name, okay? And I can go probably a whole hour session on just that topic alone, but just understand that if you do get a trust up, you want to make sure that you actually fund the assets inside the trust, okay? And then also the distribution of assets in a timely manner and in an efficient manner. Because once you have the trust set up, you have the assets funded into the trust, upon you passing, things are going to pass seamlessly to your beneficiaries, because everything's outlined. It's a legal document. It's a live entity that passes on after you pass away. So those are the major differences between a will and a revocable living trust. Which one is right for you? It depends. We love to take our clients through the estate planning process to identify which one is right for them, what makes the most sense, and then also walking them through getting the document set up, so that way that part of their financial planning process is at ease. They can be more comfortable and ensure that upon their demise, everything gets passed the correct way. So once again, guys, we appreciate you guys coming on as always, and we'll talk to you again next week. Thank you.